When to update your estate plan, the 6 life events that might mean that it's time to either update your estate plan or have it reviewed. My name is Michael Pevney. I am an estate planning lawyer and I set up estate plans for families in California. If you are interested in this or anything else related to estate planning, you can always follow me on whatever platform you're watching this on. Ask an estate planning question in the comments, and if you haven't set up that estate plan or you need to make changes to that estate plan, you can always find me at ocestateplanlawyer.com. The link should be in the comments here, and let's start talking. So here are some of the life events that means it might be time to set up an estate plan. Now, this is all assuming that you have some sort of estate plan set up. So first, there needs to be an estate plan. First, if you have nothing set up, no will, no trust, no advance directive, no power of attorney, probably best to speak to a qualified estate planning lawyer in order to best set that up. So if you do have that estate plan set up and you are entering a new marriage or a new serious relationship, having that plan evaluated, depending on the state you are, is going to be something that it's important to do. For example, I live in the state of California. My clients are in the state of California, and California is a community property state, which means everything belongs to you before you're married, but the day you get married, unless you have a prenuptial agreement, which is its own separate thing, everything that either spouse earns after that date is considered community property, which means that you might not have complete control over every asset that you earn. So if you have an estate plan set up as a single person, we might need to make some alterations to that, making sure that your assets go to the people that you want in the way that you want. Otherwise, we can end up with a lot of conflict there, because your spouse, if you pass away, does have a legal right to any community property that you have amassed, meaning any of your earnings after the marriage. And if you want to leave things to someone else, basically it has to be okayed by your spouse. So that may mean updating a will, updating a trust, or creating a new estate plan with your new spouse. If it's a second marriage or somebody has kids from a previous relationship, we may need to plan for both you and your spouse, especially if there are children from a previous relationship, because oftentimes we want to accomplish a couple of goals. First, making sure our spouse is cared for the rest of our lives, but also making sure that our children from a previous relationship are also cared for. So that's the first reason we might want to have an updated trust or an updated estate plan. Reason number 2 for doing this is, well, it's the opposite of marriage. It is divorce. So there are a few things involved with an estate plan. Obviously, most of them are centered around a will or a trust as the central estate planning document. Most of my clients in California, we set up a living trust, a revocable living trust, especially if you own real estate in California, because we really want to avoid that court probate process. Maybe that's something you've had to go through with a parent or a grandparent or a relative, or maybe it's something that you've heard of. It is something that we really want to avoid. But if we have something set up with a spouse and we are no longer with that spouse, probably time to set up a new trust or a new will, probably because we don't want our ex inheriting things. There are other aspects of an estate plan beyond just a will or a trust that we might want to remove our now ex-spouse from that plan, like a financial power of attorney. We don't necessarily want our ex being able to control our finances while we're alive. A document like an advance healthcare directive, where we appoint somebody else to be able to make healthcare decisions if we are not able to. Not a great idea for most people. Some people have an amazing relationship with or get along with their ex really well, but for most people, we don't necessarily want them to be able to make healthcare decisions for us when we're no longer married to them. One of the biggest pitfalls I see, and which is part of estate planning, is naming beneficiaries. Especially, let's say we have the same job that we had when we initially got married, and our 401k, we have our spouse as the beneficiary. Now it's our ex-spouse. And when you pass away and we have an ex-spouse as the beneficiary, in almost every situation, guess who's going to end up getting that money, even though we don't necessarily want them to, because the bank and the 401k company has on record your ex-spouse. Similarly, life insurance. Let's make sure that we don't have ex-spouses named on a life insurance policy unless you really, 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 really want that ex to get it. And let's not fall into a trap, and it's a little bit of a trap, of saying, well, my ex is still the parent of my children, so they're going to use it to take care of a child. The much better way to do this is to set up a trust, making the children directly the beneficiaries, and then having a third party, somebody that is not your ex, be the one as the trustee, the person that would have to be administering that trust. So marriage, we want to reevaluate that estate plan. Divorce, we want to reevaluate that estate plan. Birth or adoption of a child and sometimes a grandchild. When new family members enter the family, especially if we don't have kids before, an essential estate planning document that we want to have is a document that appoints a guardian for our child so that we have some say in who cares for them, who takes care of them if we pass away. Oftentimes, if there are additional children and if we are leaving things equally to those children, we can make provisions initially when we set up the trust to make them flexible to accommodate different children when we pass away so that things are left equally to them. But it can be an important part, especially depending on the way things are written. Most of my clients, even though the document is pretty flexible, if they have another kid, we want to make a quick update to the trust, acknowledging that this child exists and that we intend for them to be a beneficiary. And let's always remember making sure to update guardians. Also, we want to think about how old is our guardian going to be when our youngest child turns 18. Sometimes if we have one kid and then 3 years later another kid, and then 3 years later another kid, and maybe our parent is listed as our beneficiary, sometimes we want to think how old or what's the health condition of that parent going to be when our youngest child turns 18, which is why a flexible and well-written estate plan is always going to have alternates for all of these positions. Our next trustee, our next guardian. So birth or adoption of a child is essential in making sure that our trust is effective in the way that we want it to be. Number 4, buying or selling a home. Again, most of my clients I set up a living trust for, but a trust is sort of like a bucket. If you see a lot of other videos that I've created, I analogize a trust to a bucket that we put stuff into, take stuff out of. When it comes to real estate, it is very important that the title of the home be titled in the name of the trust. So my wife's name is Heather, so Michael and Heather, trustees of the Michael and Heather Living Trust. But if we sell that home and purchase a new home, we similarly need to have that home properly titled in the name of the trust. Otherwise, it can be a big headache after you pass away to get that home into the trust, and there is a chance that it could end up in probate. Where I am in California, average home, $40,000, $50,000, $60,000 to get it through probate. If it is properly titled in the name of the trust, it could cost nothing. Do you have to speak to a lawyer to title a new home in the name of the trust? Maybe, not necessarily. Sometimes I get an email from a client that says, we're buying a new home. Can you remind us on what to do? And I basically email them back and say, yes, this is how we do it. And by the way, when we initially set up your trust, you have some written instructions about how things are supposed to be titled. So purchasing new real estate, it's essential that that real estate be titled in the name of the trust. So that's number 4. Number 5, receiving an inheritance, a large inheritance, or a major financial change. For most of us, we want the bulk of our assets flowing through our estate plan, flowing through our trust. And so titling things becomes very important. So we want assets titled either in the name of the trust now, whether that is a checking, savings, non-retirement investment account. We're able typically to title things in the name of a trust or make sure the trust is a beneficiary. And especially if we want to have a lot of control over how these assets are distributed, including inheritances, if we're going to be opening a new account, they usually encourage you to name a beneficiary, but we don't necessarily just want it to be our spouse and as a backup our kids. oftentimes we want the trust somewhere in the line of succession there. Oftentimes a spouse as a primary beneficiary if you're married, and then maybe as a secondary or alternate beneficiary have the trust itself named. So if we do receive inheritance and if we are opening new accounts, we want the trust somewhere either titled in the name of the trust or have the trust in the line of beneficiaries there. And the sixth reason that it might be a good idea to update an estate plan is if we want to change who our decision makers are. And this is beyond divorce. Maybe our next trustee is not in good health, or we have lost faith or trust in them. And we call them a trustee. We call it a trust for a reason, because we are entrusting our next trustee to do what we say when we set up the trust. First, it's always important that the documents be flexible when we initially set up the trust so that we have at least one backup for almost every position, every decision-making position, and even for beneficiaries. But sometimes a trustee passes away while we're still alive, or heaven forbid, a beneficiary or a child even passes away while we are still alive. First, we always want alternates named in the documents, but if we want to change things and make them rock solid for any other reason, or we want to change the order of our trustees or our decision makers, that is time to revisit the trust documents themselves and the entire estate plan, because oftentimes our next trustee is oftentimes going to be somewhere in our durable power of attorney, the person that makes financial decisions for us. So sometimes I get the question, how often should we be reviewing a trust? I mean, every 3 to 5 years or so is probably a good idea to have somebody look over it, whether that's the attorney that you set things up with, or maybe, if you didn't set it up with an attorney, not necessarily the best idea, or if you didn't like the lawyer you set things up with, maybe have another attorney in the state you live in that's qualified and experienced and has some idea what they're doing to take a look at things. That's a general rule every 3 to 5 years, but definitely if there are those big life changes. And the 6 ones we went through are getting married, getting divorced, the birth or adoption of a child, purchasing or selling new real estate, receiving an inheritance or a big financial change, and if we need to change who our decision makers are. So hopefully that gives you a little bit of an overview about when it is time to update and potentially change the terms of a trust. Once again, to introduce myself, my name is Michael Pevney. I am an estate planning lawyer. If you have any questions about this or anything else related to estate planning, ask a question in the comments. I've got a lot of videos out there, so you can always follow and subscribe to whatever channel you are watching this on, follow me for more estate planning information. And if you live in California and it's time to get that estate plan created or changed, you can always set up a time to speak with me for free by going to my website, ocestateplanlawyer.com. You can also just visit my last name, Pevney, P-E-V-N-E-Y, Pevney.com, and that'll take you straight to my website. And there's a lot of resources there as well. Thank you for your time. Thank you for your attention, and goodbye.